Welcome to the Foreign Report, your weekly foreign policy show that gives you the gory details of geopolitics with hopefully some laughs along the way. I'm Seena Ghaznavi, your foreign policy curious host, with our guest host, comedian, director, Columbia Journalism School graduate, Travis Irvine. Travis, we got an interview today.
Well, I'm very excited. Who knew that the Supreme Court could be so terrifying, but also funny in a lot of ways when you really dig into it?
We get into a lot of it. We've got constitutional law professor and host of The Oath in the Office with John Fugelsang, the podcast, Corey Brettschneider. He's back, our first return guest, which is fun. There's a lot that happened with the citizenship case, which is clearly a foreign policy thing that we wanted to talk about. And then there's these religious cases, which are terrifying to me as a person that's from Iran, and that it's a theocracy there. And as we've seen over the last couple months, when religion and policy mix, there's always peace.
It always works out. It
always works out.
And of course, as we say on the show, domestic policy is foreign policy. What does these kinds of decisions, what does it mean for the rest of the world? So I really appreciate Corey's expertise on this, because Lord knows I ain't no lawyer.
You look like one. You're more like you're like law enforcement now.
I did want to just say, for the visual viewers of the show, I did finally do what Seena and many fans in the comments have been demanding. I did shave my beard. It was time for me to decide which side I was on in this whole Iranian conflict, I guess.
I like the little, what do you call it? The soul patch?
Soul patch, yeah. I went from Amish boy to Frank Zappa. I think
there you go.
The logical progression of anyone's facial hair.
That makes a lot of sense. But man, this Supreme Court, it's insane, the decisions that they're just coming out with. And they keep saying the Supreme Court is nonpartisan and all this stuff like that, but then the media just is like, it was on party lines, it was on liberal and conservative lines. It's like, I don't know, we'll talk about it with Corey, but I'm in favor of expanding the court. More justices on the court means you'll have more balanced rulings. You won't have one or two of these people that are super arch conservatives or super liberal ruining the decision for the rest of the country. You should have just some more balance. It's crazy.
I agree. And I think we get into it with Corey. This is, again, they hand down a lot of huge decisions at the end of June. So I think these decisions reverberate for the entire month of July. And then by August, we'll all forget about it, I'm sure.
Yeah. Oh, God. Again, I hope there's not a war between the time we record this and when it drops. Oh, God. All right. That's enough of that. Let's go to the interview with Corey Brettschneider. In the virtual studio, constitutional law professor at Brown and co-host of The Oath and the Office with John Fugelsang, and he's the author of The Presidents and the People, 5 Leaders Who Threatened Democracy and the Citizens Who Fought to Defend It. Corey Brettschneider, great to see you, Corey.
Thank you, Seena, Travis, nice to be with you. And I think I don't know if I'm the first repeat guest, but I'm happy to be a repeat guest.
Oh, I think you are the first repeat.
You got it.
You might be.
That's your moniker.
Think about that.
Repeat guest.
Here we are a few days before July. We're pre-recording this because I'm going on vacation in July to Japan. So let's see if anyone can find me. Let's see it. It's July 1st. And I, because I went to law school and spent a lot of money that I took loans out against the government, one thing I know is that the Supreme Court sends its decisions around the end of June. And I was like, we got to get Corey back to talk about what will certainly be a hellish list of decisions.
Oh, nice.
Well, I mean, one day we'll bring you on to talk about, I don't know, like gummy bears or like flowers or something like that, if there's a Supreme Court case related to that. But in the meantime, we're going to talk about some wildly, dramatic decisions from the Supreme Court. This first one, the big one.
Hold on. Can I ask before we start?
Oh, my God.
Sorry. I just want to, for the layman out there, Corey, what is the Supreme Court?
Okay. We're really going late.
Start with the basics.
Get laid.
Why are 9 perverts in robes allowed to have so much power?
Yes.
Please, just explain
that's a great question. I like how you spun
that.
That.
A small question.
You really turned that one. You saved that one. I like it. Go for it.
I've been saying, John Fugelsang, my co-host on The Oath in the Office, has said a few times, I have a stupid question, and I say to him, which I really mean, I grew up with my mom, who was a guidance counselor and a teacher, saying there are no stupid questions. And her theory was, there are better or worse questions, but, doing that, having that attitude allows you to ask things that you might think are stupid, but are actually profound. And quite seriously, Travis, I think that question is the most profound to ask, not certainly at this moment, but generally too. And so I'll start with that. And I think we could talk about it too, because and I'm not exaggerating. I mean, I start all my classes, whether I'm teaching in law schools or at Brown for undergrads, with that question. And it's called the counter-majoritarian difficulty, is sort of the fancy name for that same question. What it asks is, look, the Supreme Court has a system of judicial review that goes at least back to Marbury versus Madison, really before that, a case called Calder versus Ball, and even to the Federalist Papers themselves. And the system that we have in the United States is, really unique in many ways, the system of judicial review. And what it says is, look, what these people can do, and exactly as you put it, 5 out of 9 people, and let's remember too, unelected, they are almost all graduates of the same Ivy League schools. And at least throughout American history, white men have well predominated those numbers. So, what is it about these people that gives them this unique power of judicial review? What is that power? It's the ability to say any policy, executive order, law passed by the states, statute passed by Congress, to hold it up against the Constitution itself and proclaim these words: this is unconstitutional. And so it's not just the highest court in the country, but it is a court that has this distinct power to strike down laws passed in some cases by millions of people. Think of what it takes to pass a statute passed by Congress, and actually to just end it, to stop it. That's a profound power. And so we better have a good answer. My answer used to be, well, they're defending the rights necessary in a democracy, rights like free speech, like rights like equality. And that answer doesn't really work.
Yeah, emphasis on used to say.
So my quick answer is, this isn't really a court. It isn't a court that is justified in its use of this extreme power. It's a partisan organ of the Republican Party, and it's really acting with power but without legitimacy. So
Travis's profound question made me think of another question as well, because, Travis, you mentioned, why do these 9 people have all this power?
And I called them perverts, to be fair.
Okay, God, thank
perverts
you.
in robes, which I don't know why that's a tradition. But
Kavanaugh's got nothing on underneath that thing.
I don't usually say that in the beginning of my classes, but I could think
that you admit that.
I'll own that one. I'll own that one.
So there's 9. Were there always 9, and can there be more?
Yeah, the number is not fixed by the Constitution. There have been less. There could be more. And one of the real questions at this moment is, well, what to do about this, abused power. And we're going to talk about that. We haven't shown that yet, but I think by the end of the hour, people will see why we're talking that way. And yeah, one of the many options for court reform is to, through statute, to change the number and to nominate and have confirmed by the Senate additional justices, so that these justices' votes are diluted. The number certainly is not fixed by the Constitution, and a rectification of the going off the rails might be called for. The most famous example of a threat to add justices is FDR's threat. And there's controversy about it, but many people think the reason why the New Deal, after being struck down as unconstitutional and abuse of that power that we talked about of judicial review, the court reverses itself and allows the New Deal to go through, partly under threat, certainly, of this idea that FDR was going to change, with the help of Congress, the number of justices.
So can the president just expand the number of justices unilaterally?
My understanding is you need legislation, and then with legislation passed by Congress and signed by the president, the number would change, and then they could add justices.
I would like 15. 15 total is my number.
Yeah.
I think 15
you could do 30, and
30?
then the votes would really be diluted.
That's a big bench.
There are different ways of doing it. A lot of lawyers don't like me talking this way, and law professors especially, so they talk about court reform rather than packing the court, which is the FDR kind of era way of talking about it, or at least the way historically it's talked about. And there are interesting proposals. One is rotation, that you would take justices who are on the Supreme Court now and lower them to the federal courts. They do have life tenure, so it would be a way of respecting that. It's not necessarily life tenure on the court. And that that's an interesting idea, and that you would
Oh
rotate
man,
up.
you want to send Alito to a circuit court, man? He's not gonna get. Are you kidding me?
You're not going to be happy.
Yeah, he is gonna be pissed. No way.
That's part of the thrill.
Yeah. Well, I remember that being almost like a boogeyman of the 2024 election, right? They'd say Kamala wants to pack the court, but in reality, I think during the Biden administration, there was a lot of talk about court reforms, just even like ethics reforms, right? Because it was revealed by ProPublica that Clarence Thomas is taking all these gifts and lavish trips with billionaires he's also ruling on their cases when he comes before the Supreme Court. So what's the reality, and what's the scary part?
The thing that I think that's funny about that, though, is I think Clarence Thomas would have still ruled in the billionaire's favor. I don't think he's the gift.
Yeah. It just helps that they're also his friends.
It's pure belief that they should be benefited. That might be right. The arguments against it were that we're going to get into a battle of increasingly politicized Supreme Court. So
thank God we don't have that.
President, you've answered.
Thank God.
My own, answer to my answer. That if you had Harris, added justices in the way that I'm suggesting, for instance, well, then the next president, if it was a Republican, Don Jr. or whoever, God forbid, would add justices. And my response to that is Seena's, which is, what? We are already there. It really is hard to imagine it being much worse than it is. And, maybe it would at this stage just be more honest to say, yes, there's a set of values involved here. I don't think, by the way, the court is partisan in the sense that the Senate, for instance, is partisan. It is partisan, but it has a different vocabulary, a different set of beliefs. It tries to have a kind of consistency, although it often fails. So what you really have, I say in my book, The Presidents and the People, this isn't new either. For really from the beginning of American history, from the founding, have had two ideas of the Constitution. One, a deeply authoritarian one, and I think you're seeing that. And so John Adams, for instance, a premier constitutional thinker of his time, thought there was nothing wrong with the Sedition Act that shut down political opponents. And yet you have a democratic one, always a counterforce, emphasizing the rights that I talked about, the right to dissent, for instance, the newspaper editors who fought back against Adams and eventually prevailed. Or during the second period that I talk about, the Dred Scott Court had a white supremacist, not just white supremacists, but really denied the humanity of Black Americans by saying Black people had no rights, weren't legal persons under the Constitution. And of course, Frederick Douglass, in many ways the hero of my book, The Presidents and the People, gives this very different idea of multiracial democracy. As he says, it's an idea of we the people, not we the white people. So this is a long-standing battle between two ideas of the Constitution. That part's not new. But, the party in power has made it very clear they have an authoritarian idea of the Constitution. And so we need to do whatever it takes to push back against it.
All right, so let's get to these cases here. We've got a few to talk about, maybe a couple. I don't know. We'll see. I think the conversation is going to be pretty long for this first one. Trump v. Casa Inc. From the executive order that Trump wrote that said there is no longer birthright citizenship. And he is completely allowed to write that executive order because it's not in the Constitution. Is that right, Professor?
Yeah. Well, we don't have a final ruling on the merits of the case. So just to lay it out a little bit more, the Constitution says plain as day, if you're born in the United States, you're a citizen. That's how
it's called the Citizenship Clause, right?
Yes. And
this executive order is called, I think, the Citizenship.
It touches on the sort of intro that we were doing. Frederick Douglass championed two words that he wanted to see in the Constitution: equal protection. They're in the 14th Amendment, but they're also realized in different ways, including the idea that the rebuke to the idea of slavery, as extreme a rebuke as you can get, rather than inheriting the status of parents as being owned. You are, by definition, if you're born on American soil, a citizen. And they wrote it in such plain ways as an extreme rebuke to slavery. And we have a case, Wong Kim Ark, about whether or not non-citizens who have children in the United States, whether or not they are citizens. And the court says the sensible thing. They read the simple clause and say yes. Now, there is language in the clause that says subject to the jurisdiction thereof. So now the Trumpers are arguing, and have since John Eastman had this quack theory that I was invited to debate Eastman a long time ago on NPR, and I thought, this guy's a nutcase. I'm not going to even give it any daylight. But that view of Eastman, the architect, by the way, of January 6th, also is the architect in many ways of this idea that the phrase subject to the jurisdiction means that undocumented people who have children in the United States those children are not citizens because they're not subject to the jurisdiction thereof. Now they're subject to criminal jurisdiction, so I don't really know how the argument gets off the ground, except that when you listen to them, they have this horrible idea that the United States is under invasion in the same way that a Nazi soldier had a child in the United States wouldn't be a citizen. So too, this invading army of undocumented people. That's the way they argue it. Now, in this case, they haven't opined on that question, or the merits is the sort of fancy way to put it. Instead, what they did was they cut off the possibility that lower courts, district courts, could have nationwide injunctions, not just in this issue, but more broadly, with a very narrow exception. So they haven't answered the fundamental question. They will at some point, but they've cut off the ability of the lower courts, not just here. This is why it's such an awful, awful decision, as bad as leaving birthright citizenship unprotected is. This executive order revokes it. The worst thing that they've done is they've cut off the power of these lower courts to stop Trump's authoritarian agenda. By the way, I've been calling it, I think I called it last time we spoke, a self-coup. It's an attempt to destroy the Congress and to destroy the judicial branch. And they really are doing it. I mean, I can't, I wish I could sugarcoat this. There's no good news in this. This is the way that we've had, for instance, as our own repeat guest, Mike Zamor, the policy director of the ACLU, talking about how they've won nationwide injunction after nationwide injunction against the president. It's stopped his agenda in many ways. Now the Supreme Court has just cut off that power of lower courts.
Yeah, so let's talk about the injunction, because you said they hadn't ruled on the merits, which is like when I was listening to the oral arguments for this case, It was so funny. They just, like Justice Kagan kept saying, it's like, what do you mean? You're never going to come and put this case in front of a court on the merits because you know you're going to lose.
Yeah.
You know you're going to lose.
That's right.
And so they kept harping on this. And when I was listening to the oral arguments, I was like, oh, there's no way they're all going to be like, this is a joke. No. But this was all centered around the idea of a nationwide injunction.
Right.
That the person suing can get the government to stop doing that action through an injunction, but that the nationwide injunction broadens that stopping power to everyone else impacted across the country. Is that right?
Exactly right. And I'll say why. It's not just so important in stopping Trump's authoritarianism, but it's common sense, this ability of courts, lower courts, the district courts specifically, to have these nationwide injunctions. Because look, you have a party before a particular court. But now, in the case of an executive order, that doesn't just affect the party. It's the president and the president's entire branch of government taking people's rights away wholesale. So, of course, it makes sense that the court would have the ability, especially as the case is pending, to ensure that the damage isn't done. And the way to do that is to say, look, this whole thing is a problem, not just in regard to my particular client who I'm happening to represent. And for a long, because the ACLU, for instance, there was a nationwide injunction against the kidnapping, I would say deportation, but it's not a legal process by ICE of Venezuelans and sending them to this gulag in El Salvador. And the ACLU won a nationwide injunction. And why would there be a nationwide injunction in that case? Because the whole system of deportations is questionable. So. That's by the way, this is something that happened during COVID. There were nationwide injunctions against Biden. And it's part of the suspicion here. Like, why are they doing this now in this case? It's because they are partisan and there isn't a real justification. And to my mind, it is, an assault on the rule of law itself, because what are these injunctions? They're a way to stop the president from acting illegally, generally, not just in some small number of cases.
There is a counter argument that I've heard a bunch, that the number of nationwide injunctions that's been used has increased over time. I'm obviously not a law professor, so it's not like I'm up to date on the number of injunctions that are flying out of the courts these days. But can you give us a sense of where does that argument come from and what's the counter to that?
Well, my good friend who I've sometimes co-taught with, and I've been on her podcast as well, and I'm going to have her on mine soon, Kate Shaw, was testifying in Congress in front of Josh Hawley. And Josh Hawley, by the way, who went to Yale Law School.
Oh, yeah. I think I
what
saw
he
this
was learning
exchange.
there, I don't know. But he made that argument. And so I think that's part of why it's in the public consciousness. He said, look, he showed a chart that during Obama, there were, this many, and now look at how many nationwide injunctions there are now. And Kate, man, it was such a great moment. She said right back to him, well, Senator, I can't help but wonder if the reason why there are so many nationwide injunctions is because this president is acting increasingly lawless compared to any previous president. And that is exactly right. I mean, the birthright citizenship, the gulag, thing after thing is just not just illegal, but as I call it, a self-coup. And if you're engaged in a self-coup, you're going to have a lot of instances of lawless action. And if the courts are doing their job, they're going to stop it. Now, the pushback against that, from not just from Hawley, but from Stephen Miller in particular, was, well, this is a judicial coup because the president was elected and can do whatever he wants, the authoritarian idea of the Constitution. And what's so enraging about this Casa decision is that the Supreme Court has affirmed Stephen Miller's view, as wacky as it is, and they've shown him to be right in the words of this lawless court.
Let's can we play when the decisions came out? There was a press conference, and Pam Bondi and Donald Trump both spoke at this press conference to spike the football, as it were. And then I want to get into the opinion a little bit more specifically. But let's play the can we play the Bondi clip?
We have rogue judges striking down President Trump's policies across the entire nation. No longer. Today, in the 6-3 opinion, Justice Barrett correctly holds that the district court lacks authority to enter nationwide or universal injunctions. These lawless injunctions gave relief to everyone in the world instead of the parties before the court. As the Supreme Court held today, they turned district courts into the imperial judiciary. Active liberal judges have used these injunctions to block virtually all of President Trump's policies. To put this in perspective, there are 94 federal judicial districts. 5 of those districts throughout this country held 35 of the nationwide injunctions. Think about that. 94 districts. And 35 out of the 40 opinions with nationwide injunctions came from 5 liberal districts in this country.
This is where all the shit happens. This is D.C., New York. Where else is anything happening?
Right. But then I'm also thinking, like you guys are saying, to the Biden administration, when the same thing, you also had activist judges in conservative districts. The guy in Texas, they always go to Louisiana, Florida. Those were conservative districts. So when the shoe's on the other foot, they were fine with it. But now, call me crazy.
Also, the way she phrased it was liberal districts, because some of the judges are Republican appointees, including Trump appointees and Bush appointees. So she's being, disingenuous, of course, in her language. And, it isn't just Democratic judges doing this. It's judges wanting to uphold the rule of law. So I believe Judge Boasberg, who in the Venezuelan deportation case put a stop to it, that's not a Democratic appointee. And it's the rule of law versus authoritarianism. And that's why there have been so many of these, as Kate Shaw pointed out, so many of these instances of district courts doing their job by stopping this attempted self-coup. And of course, they reverse the language, as they always do. Oh, no, it's the judges involved in a judicial coup. That's their argument.
Yeah, they always like to flip it there. One of the things that she talked about was that it applies to the whole world and not to the parties involved in the case. And one of the things that I remember hearing them talk about, again, I think it was Justice Kagan in the oral arguments, I can't remember, but they were like, she was saying something, and this is what came up in the case as well, and what came up for me reading the opinion is, does every individual person now have to bring a case before the court if they want to get relief? So, like, this case in particular dealt with a pregnant person and their child getting relief, and relief as in being able to become a citizenship. become a citizen of the United States, and that baby, that soon-to-be born child, is going to be a citizen, but a future pregnant person will not be given relief. They will have to, and please correct me if I'm wrong, they will have to file suit on their own. They have to go find a lawyer, pay the retainer, pay the hourly, or get someone to sponsor them for free, start a GoFundMe, and then get a court case going in district court, and then appeal all the way. Is this where we're at? Is this what's happening?
Well, the first thing I'll just say is the common sense at the root of your comments, which is that, if you're similarly situated, the rule of law seems to suggest consistency. So if it's unconstitutional in regard to, a person from country X who gives birth, that kid is a citizen. Well, then if you're from country Y, it doesn't make any sense that you would need a different case. That's the idea of the nationwide injunction. Now, it's right to say they've cut off that possibility. I don't want to go so far as to say each litigant has to bring their own case, because there are other ways to bring these large actions. One is class action, so you have to get the class certified. Now, this court's limited class action, so that's harder, but it's at least one way to do it. And they did, in the opinion, leave this possibility, which is that a kind of standard in which there was a severe harm to somebody, if there wasn't a nationwide injunction. It left open the possibility that you could have them, but it's a pretty narrow route. And litigators who I respect greatly, who I've talked to, are telling me it's not real. I had somebody actually call me out on Blue Sky because I was using more universal language of saying, they stopped universal injunctions. And the person pointed out to the paragraph that Justice Barrett has that left open this route of irreparable harm, that you could have a nationwide injunction. And at first I was like, okay, fair enough. Maybe I should clarify it. But, there's a danger in that, because if you're too careful, she's putting that in there to make herself look sensible.
Yeah.
She really, de facto, was cutting off the possibility of these nationwide injunctions, and yet she wants to look so reasonable. She did that. They did that too in the immunity case. Oh, it's not all presidential crimes. You could have some unofficial acts, for instance, that are present. Well, it's just their trick, to try to make it look like they're not doing the harsh damage that they are, but they are. So I would say the nationwide injunction basically is dead, but there are other ways of stopping this, short of each litigant bringing a case, and that's class action. Also, by the way, if you win at the Supreme Court, and I do think that this is so obviously unconstitutional, for the reasons that you're saying, that if they ever get the case, they'll have to say it's unconstitutional. Well, that would also stop it for everyone.
Oh, Travis, you want to jump in real quick?
I did want to just get a sense from Corey on the trickle-down effects of this, because it's like you said, this kind of questions the whole judicial system.
Yeah.
Like, I'm from Ohio, it's a red state. The state house will pass some wacky things, and then you'll have a county judge, right, which is how it's supposed to work. ACLU, Planned Parenthood, they'll sue in a county court that's favorable to them, and then it stops the law from happening all across the state because of the system, right? And so is this going to start?
It's the way it worked. Now I'm not so sure, because the way it would work, just to fill that in, it's a great question, is the ACL. And, let's be frank, there are several litigation groups, but the ACLU, and it's the reason why I keep having Mike Zamor from the ACLU on as a repeat guest, because they're doing the huge amounts of these cases, and nobody compares to them in terms of their scope and strength. They have 4 million members, and they're just everywhere. Now, their power has come in the past from the ability of going into these local courts and winning, not just for the case in question, but getting district court judges in particular in the federal system to say, no, put a pause on this until the Supreme Court opines or until I'm overturned. And that power, which is so, it's why this is such a big deal, is gone. And now, it's not that you can't win as a party. You might ultimately win in the court, but, good luck while you're waiting. Your rights are being deprived. And in so many of these cases, Seena, to just double down on this, if you're sent to the gulag in Venezuela, like the administration, ICE, Homeland Security, they're not getting you back. So it's a wrap. They're basically, without this power, it's very, very precarious how our rights get defended at all. And that's why the whole thing is an assault on democracy itself.
And that's the plan. If they can't have the nationwide injunction, yes, that person bringing the case will get relief, but that gives them time to pull and kidnap and rendition those other people before
Right.
they have the ability to file suit. Let's go to this Trump clip. Also, our stable genius president.
Thanks to this decision, we can now properly file to proceed with these numerous policies and those that have been wrongly enjoined on a nationwide basis, including
He's so
birthright
bad at reading.
citizenship, ending sanctuary city funding, suspending refugee resettlement, freezing unnecessary funding, stopping federal taxpayers from paying for transgender surgeries, and numerous other priorities of the American people. We have so many of them. I have a whole list. I'm not going to bore you, and I'm going to have Pam get up
bore
and
you.
say a few words, but there's really, she can talk as long as she wants because this is a very
You could
important decision. This is a decision that covers a tremendous amount of territory. But I want to just thank again the Supreme Court for this ruling.
You stop thanking them, you bum.
I think you're right, though, Seena. He says, I don't want to bore you, but I think what he really means is I can barely read any of this, and I don't know what it means.
I'm not understanding.
Let's get Pam. Where's
Get Pam.
Pam?
What
I need
did I
Pam.
say? Words? What's happening right now? Yeah, we're going to talk about some of the other cases that are going to happen here. Let's take a quick break. I don't even want to talk about him talking. I thought I wanted to do like a whole riff on. I was like, I am so disgusted by him. It's awful. By him reading. That's what I mean. I think he's a great president. He's just a bad reader. I think that's what I'm saying.
Thank you for clarifying.
Yeah.
You gave yourself a carve out like Amy Coney Barrett there.
That's right. I gave it a little bit of an out. Let's take a quick break, and when we come back, I want to talk about a couple of segments of the opinion that I found that I thought were very robust from Amy Coney Barrett, where she claps back at the dissent, and I think there's going to be a mortal combat. So stick around after the break. We'll be right back. This is the Foreign Report. Travis Irvine, Corey Brettschneider. We'll be right back after this. Welcome back to the Foreign Report. I'm Seena Ghaznavi. Professor Corey Brettschneider is with us in studio. He is the co-host of The Oath and the Office with John Fugelsang, and he's the author of The Presidents and the People, 5 Leaders Who Threatened Democracy and Citizens Who Fought to Defend It. Travis Irvine is with us in the virtual studio as well. All right, so I'm going through this thing. And one thing people have to remember is that when opinion gets written and the person writing the opinion references another justice, it gets written in all caps. So if it is a millennial, if you see all caps in word form, you're screaming.
I'm shouting.
You're shouting.
Why
at
am
that
I
person.
shouting? I'm not shouting. You're shouting.
And there are multiple times when Justice Barrett is calling out Justice Jackson, and it just seems like an angry Karen yelling at a black woman. Okay,
boy.
it just seems like. It just reads as that. I don't know if there's going to be some sort of Mortal Kombat, but I want to get to that in this segment here and talk about some of the when Scalia, when I was in law school, we would read Scalia opinions. He would put Bob Dylan lyrics in there. Okay, for whatever he thought about Scalia, he'd throw a little funny little quip about Bob Dylan, and Bob Dylan would be like, "What the fuck?" So these things used to happen. But Justice Barrett is like, this is like Mean Girls. Okay. And I couldn't believe it. Barrett also clapped at Justice Jackson's dissent, saying that it was, quote, at odds with more than 2 centuries worth of precedent, not to mention the Constitution itself. We observe only this. Justice Jackson decries an imperial executive while embracing an imperial judiciary. She also goes on to reference the Judiciary Act of 1789, which is part of the judge's oath, and then Barrett goes on to say, quote, Justice Jackson skips over that part because analyzing the governing statute involves boring legalese. She seeks to answer a far more basic question of enormous practical significance. May a federal court of the United States of America order the executive to follow the law? In other words, it is unnecessary to consider whether Congress has constrained the judiciary. What matters is how the judiciary may constrain the executive. Justice Jackson, let me do this better. Justice Jackson would do well to heed her own admonition. Everyone from the president on down is bound by the law. That goes for judges too. Is this like Mortal Kombat? Is that what I just heard right now in like Supreme Court talk?
I mean, this reminds me of a Wendy's, honestly.
And then Jackson, too, at the end of her dissent, usually they say, I respectfully dissent. I can't remember her exact words, but it's essentially like the house is on fire. You know, she's sounding the alarm by not using that word. She doesn't want to pretend to have respect for Justice Barrett, because it is, you know, and it's such a weird case to do it. Seena, you said before how, you know, this is almost certainly not a winner on the merits. So yet they're using this case, which obviously is unconstitutional, case of an executive order revoking something written explicitly into the Constitution to destroy the power to actually protect our civil liberties. And that's why the language is so harsh. I mean, to pull back a little, the thesis of the book, The Presidents and the People, is that we've had these authoritarian threats before by presidents who really did want to shut down basic civil liberties of the Constitution and even democracy itself. But they don't do it by saying, hey, I hate the Constitution. John Adams, the premier thinker, constitutional thinker of his time, Woodrow Wilson, a premier constitutional thinker of his time, even Richard Nixon, a lawyer, they couch all of this in the language of law. And what my bigger point is here, to come back to the specific issue, is what Jackson is doing is she's acting in this tradition of trying to defend a democratic constitution, all the while that Barrett is trying to enable this authoritarian one. And so when that comes out in raw terms, it's not going to be polite. They are talking about two totally different ideas of what the law is. And although there's an unfortunate tradition in Barrett's camp, it's not a glorious one. And that's what Jackson is so frustrated by.
It's so crazy. Going to the dissent in, I was reading Sotomayor's, and I guess before I get to that, though, in general, we kind of referenced this before the break. How does this case get challenged on the merits, and what can the administration do while that's being processed? Can they just be a baby of an undocumented person just gets born and then they're renditioning them to El Salvador? Is that what is presumably able to happen now?
Good. Yeah. I mean, just to be specific about it,
goody.
You know, that's why the house is on fire. That's why this rhetoric is, you know, could be even more heated given, and I've been going on television using this phrase, self-coup. I did CNN today and MSNBC, and people kind of look like, really, it's a coup? And yes, it is a coup. It's if we were reporting on this from, you know, I'll use the example of Latin America because political scientists study it in comparison to the United States, because most Latin American constitutions are based on our own. They have a presidential system. And what defines almost all of them is that they've broken down into executive power, into dictatorship, because the system is very fragile. And that's what you're seeing right now. That this isn't any office, the office of the president. It is so powerful. The framers worried about it. At the founding, Patrick Henry, the revolutionary hero who said, give me liberty, give me death, also said, don't ratify this constitution, because if you have a criminal president, none of these supposed checks and balances are going to work. The president is going to destroy Congress, destroy the courts. And who's going to stop a criminal president? Like there's going to be immunity. He predicts all of this. And now it's all coming to pass. We're seeing the kind of collapse. So if we were reporting on a Latin American country where this was happening based on the presidential system, we'd say, well, the president shut down Congress, the president's shutting down the courts, and that's what's happening. So, you know, to go now to the specifics, so birthright citizenship the merits haven't been decided. Instead, what's happened is these universal injunctions are gone. So what it means is that in some places, there might be limits within the district and within the state on birthright citizenship, and some places there aren't, on the executive order revoking it, I should say. So you have a patchwork that there are going to be lots of instances in which Republican deep red states certainly will deprive the children of undocumented people of citizenship. And how is that going to arise? There'll be a number of cases of deportations, maybe some involving deportation to Venezuela or Sudan, in which they'll say, yeah, we can seize these people and take them, including these kids, because they're not citizens. That's how it's going to happen. And then, you know, ACLU or some litigation group will challenge it, but it's going to take time before we see the actual case get to the Supreme Court. By the way, they can never take the case if they want. They just would rather not. They have this power of, it's called the writ of certiorari. They decide what to take or what not to take.
Travis has brought this up before, but domestic policy is foreign policy. And this is clearly something that's going to send a signal throughout the world that we are not welcoming of immigrants here, that this very core principle that stems from the very foundings of our country and to fix a vicious wrong that we had is no longer part of an American value. I just can't imagine that not having ripple effects.
I think it is already. I just came back from Finland. I was invited. Actually, it turns out there are listeners to the podcast who knew that we had fans in Finland. We're like the David Hasselhoffs of podcasting, I guess, a bit, big in Germany and Finland. The Finnish parliament has a think tank that invited me to talk to members of parliament and academics and some members, actually, the president's cabinet. And they have a president in the parliament in Finland, hybrid system. Anyway, I was in a horrible discussion in some ways with many of these people where they were talking about, even though this was a segment in the afternoon of researchers talking about how they don't want to come to the United States. And one of them, in profound remarks, said, maybe it's a 1% chance that I get sent to one of these detention centers because I'm critical of the president. But I'm not going to take that risk. I have a family. And so, that kind of logic is everywhere. I was in Oxford and talking to a professor there before that at another event, also giving a talk on the presidents and the people. And, people are interested in the shutdown, I should say, of democracy, and that's how they see it. And they were talking about burner phones for faculty being provided because they don't want to have their social media as they cross the border. I mean, we are seen by the rest of the world already as an authoritarian state. I should retweet it, but I had some Trumper on Twitter found a clip. I recorded one episode of The Oath in the Office from my hotel room in Finland, and MAGA was so upset with me and said, "Can you believe that Corey Brettschneider is traveling around the world trashing our president?" It's like, yes, that is what I'm doing, because the threat is real and people need to know everywhere what we're, suffering through.
Yeah, I think it's very alarming that the Finnish think that we're finished. There you go.
I should have had that line at the ready.
Feel free to use that in Finland. I'm sure it'll crush.
It only work there. You brought up the two schools of camp and the Barrett camp. One of the things that came up in Sotomayor's dissent was pointing out the fundamental difference between the textualists and the legal realists. The textualists can read the case in a vacuum almost and with their head in the sand and blind to the repercussions of what would happen if they make a decision, whereas the legal realists can't help but see the world for what it is and what's going to happen. Do you see that as a good example of happening here as well?
I mean, I love that question too. It's a profound question in the same way that first question that Travis asked about the counter-majoritarian difficulty is. I mean, how should you read the Constitution? I think we have to debate that. How should you read statutes like the 1964 Civil Rights Act? And the dominant approach is supposedly textualism, although I don't think they take the text seriously. They replace the text often with their own ideology. And there's no better example of where they're not textualists than what we're talking about. Birthright citizenship is so explicitly written into the Constitution, and yet they make up this phony baloney stuff about the word jurisdiction that is not textual. It's a lie, if anything. So I don't think they even hold to their own theory. And Justice Scalia, the most famous textualist, I would prefer his views any day, for instance, on religious freedom. I can't imagine in the birthright citizenship case he would be doing anything but laughing at this executive order. But I also think it's not a full view that the text matters, but that also what matters is intent. So in the case of the 1964 Civil Rights Act, which they've been rereading to turn into a white rights statute, which is not what it is. It's an anti-subordination statute championed by Martin Luther King. You need to think about the intent too. And then the third thing I think you need to do is think about the values, the principles of provisions like cruel and unusual or equal protection or discrimination, if we're talking about the 1964 Civil Rights Act. So legal realism is a different approach. It tends to focus just on power. And I think it can be helpful because you see, for instance, that this is a power struggle in many ways at the current moment. But for me, for a kind of, a principled approach, a democratic approach is the way that I've been calling it. I think we want to do more than just say it's about power. I think we want to champion the right way to see reading a law, or reading a statute, and reading the Constitution.
I love that. Thank you. Two more quick points on this that I want to ask you about. Sotomayor talks about bad faith, that this this challenge to the injunction is in bad faith because the underlying case is blatantly unconstitutional. So there's all this talk of like, what rubric do you analyze this case on, all this stuff. We don't need to get into that kind of stuff. But tell me about that part of it. How did everyone not agree that this is in bad faith in and of itself? Is it because they all bought the argument that the jurisdiction argument that you were referring to earlier, or like how does that happen?
I mean, there are at least two votes for that. I think Thomas and Alito, who are just so craven in their approach, it's a kind of anti-immigrant bigotry, I think, in many ways that they reveal, and indifference to the suffering of anyone but their fellow political allies. And so, yeah, they're so ideological. I think they're willing to buy what is this BS argument. But I still believe there are not 5 votes for that when it comes to Barrett, for instance, and Roberts. So, we don't know the details. The court is still this secret chamber. And I imagine that, instead of going forward with the merits, which would have been a loss for the administration, they decided instead to cut down on the power of federal courts. I can't think of a worse case to do it in because it is so obviously unconstitutional. And they've never denied that because they don't have the votes for it, I think. So, what's going on here really is what you're saying, Seena. And I don't know. It's just, I found it just shocking and there's a lot that's happening that's shocking, but that you would take this executive order that is a revocation of the rights textually explicit in the Constitution. Textualism is supposedly the conservative way of doing it. And then use it to destroy this power that the federal courts were using, during Obama and during Biden. And I never heard a lot of complaints about it then. It's partisan, unfortunately. And bad faith is a great way to put it.
Last question is one that Sotomayor posed in her dissent as well. And what happens if there's an executive order that bars women from receiving unemployment benefits or black citizens from voting? What happens then? Does it get through unless each individual person brings suit, or how would that work? If
you could have
ability to have a universal injunction.
You could try this narrow way of trying to revive the universal injunction, showing irreparable harm. That's probably not going to work. So yes, class action would be the way, and you'd have to get
a
class
group of
certified.
People getting together.
Yeah, you'd have to get a group of litigants.
Which takes what, 3 days? 4 days to put an entire nationwide class together?
It just takes this, the ACLU, and their allies have just been so heroic. But the reason they've had success in slowing things down, even if they don't stop them eventually, because this stuff does eventually go to the Supreme Court, but at least it stops it in the time being. And often Trump in the past, as a result of these universal injunctions, would amend. Think of the travel ban case.
I was just thinking
which I think you and I talked about a lot, that there was a universal injunction, then they rewrote it, then they rewrote it again. It's at least slowing down the agenda and sending the message, no, you can't do whatever you want. By the way, when I say Trump has an authoritarian idea of the Constitution, he actually said during the 2016 election and soon after, things like, I have in Article 2, it says I can do anything I want. The reason our podcast is called The Oath in the Office is because Article 2 says word for word what the president has to say the first few seconds in office. They have to pledge to preserve, protect, and defend the Constitution. That's the democratic idea. George Washington said in the first inaugural, I just took the oath. It says, that I'm bound to the Constitution. If I violate it, criticize me, upbraid me. If I really violate it, subject me to constitutional punishment. Again, the democratic idea. Trump says, I have in Article 2, it says I can do anything I want.
Admittedly, we know he can't read very well.
I'm going to
So
have
I think you're being a little harsh, Professor.
Pam, can you read Article 2 and just tell me? I can do whatever I want, right?
Even that phrase, I have an Article 2, like, what?
Yeah.
You do not know what you're talking about. I
have an article.
Yeah, you can barely get Article 1.
I've been teaching 22 years. When a student says, I have an Article 2, I'm like, you did not do the reading. And the Constitution's not that long. That reading was not extensive. You did not do the reading.
All right, let's take a quick break. When we come back, there's 2 religious-based decisions from the Supreme Court that cut both ways, which I find really interesting. So this is the Foreign Report for Travis Irvine, Corey Brettschneider. We will be right back after this. Welcome back to the Foreign Report. I'm Seena and we are talking about the Supreme Court season as I am out on a bit of vacation in Japan, which, by the way, has very difficult immigration stuff happening there, too. It's very hard to become a Japanese citizenship, and they're relaxing it. You know why? Because their economy is taking a hit. So they didn't let anyone in, and now they have to bring people in to do it. So, hey, there's going to be problems in the future. We'll see how these things go. With us in the virtual studios, Travis Irvine, of course, and Corey Brettschneider, law professor at Brown and co-host of The Oath and the Office with John Fugelsang, and he's the author of The Presidents and the People, 5 Leaders Who Threatened Democracy and the Citizens Who Fought to Defend It. All right. So these religion cases, all right, there was one from Oklahoma. It was a statewide charter school board and this Catholic school, and it was about establishing a charter Catholic school. Now, correct me if I've got this right here. That means if it gets a religious school gets established, that means our tax dollars get to fund a religious school, a Catholic school. And this is a 4-4 decision because Amy Coney Barrett, I guess, is she's like on the board of something, or she like helped with some legal work for Notre Dame, which is a party to this in some form. Did I get that right?
Yeah, and her colleague is, I think, one of her colleagues is the lawyer, I think, in the case. And so, yes, Notre Dame is tied to this litigation where she used to teach. And so we don't really have a final decision because of this particular case is 4-4, but Barrett recused. It's not that she's recused from the issue altogether. So when it comes up again, the idea of religious charter schools, she'll vote. And I can guess the way she's going to vote is to say that they're constitutional. You know, I don't want to sound like the sky is falling, but the sky is falling.
Oh, that's uncomfortable.
You know, the meaning of the Establishment Clause, it's, to my mind, just one of the most important parts of our Constitution. And if you'll bear with me, I just have to do a little bit of history. I've started Oath in the Office also now has a YouTube channel, and I've been doing these little videos to just promote it. And I was in Toro Synagogue in Newport, and you can watch this video about the history of the Establishment Clause. But Toro Synagogue is significant because not just because it's the first Jewish synagogue in the United States, but because it's the place where George Washington, there was an appeal to him before the Bill of Rights was passed. And the appeal was, look, our families just escaped the Inquisition. And it's one thing I've learned in my research about all this, that the Inquisition was operating in the Western Hemisphere, not just in Spain and Portugal, but it was operating in what's now Colombia, in Cartagena. There were families, for instance, that were merchants who were living in Curacao, and they were affected by the Inquisition. And they came to the United States literally to escape the Inquisition, like the actual one, which is still in existence in the 18th century. So they're not totally confident. Rhode Island is very protective of religious freedom, but this new country, like, what's this going to be about? And one of the head of the synagogue, Moses Sextus, writes to George Washington. He actually meets him in Newport, but he writes to him and he says, look, you know, we need to not just be tolerated here, but to be regarded as equals. And Washington, and Jefferson is actually this visit too, writes back, like, it's not just toleration that we're going to do equality. Now, the way to think back to this, right? Because the Establishment Clause is tricky in some ways, and I think people fail to understand how important it is to religious freedom. The Inquisition is an established religion that shuts down other religions. That's what they're worried about. It's the core idea that we don't fund a particular official religion. And yet that's what's being abandoned here, that idea, not just of the wall of separation, but of not having an official church. The Jefferson and Madison opposed in Virginia the funding of hiring of ministers. That's the sort of core idea. And yet what's happening here in the creation of these religious charter schools, these aren't for secular subjects. It's fully religious public school, is, I think, nothing less than an abandonment of that whole anti-Inquisition, anti-theocracy idea of the Establishment Clause. So that was a long rant, as John Fugelsang often says, but thank you for bearing with me.
But I think the and I appreciate that, because I think the context is really important, that, you know, we're in a place where clearly the country did not want to have tax dollars and, in a way, fund and create making one religion more important than all the other ones. And as an Iranian American who is here because my family escaped a theocracy, this is my firing line. This is what sends, like, well, we could talk all about all the other stuff. The sky falls with me on this stuff. Because for me, sliding into religion, making public policy is the scariest possible thing that could be happening in our country. And it is my January 6th. I will crawl the Capitol walls if there is religion baked into all of our schools. That is terrifying to me. But you know what? What I'd be open to is all the religions being in all the schools. Bring in Scientology, bring in Judaism, bring in Catholicism, bring in Christianity, and bring in Satanism. You got to bring in all of them, okay? You want to bring in one, you got to bring them all. I am not for one of them, okay? It's just, it is so unreal. And is this what could happen if she comes in and is able to rule on this in a different form? We potentially could have thousands of Scientology elementary schools that are charters across this country.
Yeah, I mean, I'm not huge into predictions, but here I feel very comfortable saying this is what she's going to do. That when she finds a case where she doesn't have to recuse, the Catholic charter schools are going to happen. Now, what's twisted, I will say, is that they really, there would be a version maybe of not having. Of allowing, as you're saying, a Catholic charter school that would be open equally to all religions. They just have not shown anything like that. And I'll just give you one of the most grotesque examples from Trump 1.0. As you know, Seena, I was involved as the author of an amicus brief, co-author with two colleagues, saying the Muslim ban, as it was rightly called, is unconstitutional because it shows animus against Muslims. Now, I can't think of a better example of animus towards Muslims than the travel ban, which, Trump just said, I want a complete, total shutdown of Muslim immigration into the United States. The ban, in its first iteration, banned Muslim refugees from coming into the United States, or discriminated against them openly, and allowed Christian refugees. And yet, a couple weeks before that, the court said in the famous cake case that because a Colorado commissioner, in denying the cake maker's ability to opt out of providing this cake for a gay wedding, said something about the history of Christianity being related to anti-gay bigotry, just factual history, said that was animus. I thought to myself, okay, I don't agree at all with that ruling. That's wrong. Saying something about history is not animus. But at least they're teeing up the idea of animus so that they can, in a couple of weeks, in the Muslim ban case, agree with us and say, this is anti-Muslim animus. You can't have anti-Muslim animus. You can't have anti-Christian animus. And what did they say? They said, no, it's fine. Actually, four said it was fine. Four said it wasn't okay. And one, Justice Kennedy, said, I need more information, and promptly resigned, and we never heard from him again. So, they're just not equal in their application. And that's why the Establishment Clause is there, to avoid the favoring of some religions over others, to avoid theocracy. It was profound what you said. You left a theocracy. You didn't think you were coming to one, and yet we are becoming one. That is part of this, motion towards a kind of fascism, and it's mixed up with a form of Christianity that this court is putting its thumbs on the scale of.
And I just wanted to chime in because that case came out of Oklahoma, but in my home state of Ohio, it's the same deal. The Republicans in the state house started funneling, I believe the latest count is $1 billion a year towards private Catholic religious schools. And it explicitly says in the Ohio state constitution, you cannot take public funds and set up a separate system of schools. So public schools actually sued over these private vouchers, right? They're under school voucher, school choice, but they're all going to religious schools. And they actually just won, like we were talking about earlier, in a county court. Do you think that this is because of what happened in Oklahoma? It seems like almost every red state is trying to fight that battle to be, to take this all the way to the Supreme Court, because now they're just feeling emboldened by decisions like this one.
Yeah, and they're right, in the narrow power sense, to feel emboldened because the court is really clearing the way to increasing theocracy. And, it is a kind of again, it used to be that the Establishment Clause, religious freedom, there was a way of arguing that all religions were able to use. And increasingly, the winners of these arguments are Catholic and Christian schools and organizations trying to prevail, and often trying to prevail in a way that isn't consistent with the rights of everyone. Think of the famous Hobby Lobby case. It's not a constitutional case. It's brought under what's called the Religious Freedom Restoration Act. And it's about why, Christian companies don't have to provide birth control to their employees because it's against their religion. And so that isn't just about personal belief. It's using the idea of religious freedom, the Free Exercise Clause or the Religious Freedom Restoration Act to shut down the rights of others. And, to my mind, the reason I started with that long discussion of the Establishment Clause is because it stands for what Seena rightly identified as the core principle of democratic freedom, which is anti-theocracy. And yet what these decisions are doing, and it's like the self-coup. You don't just see it. Nobody said, Trump doesn't say, I'm going to have a self-coup now. There's no military. I mean, we did have violence, of course, in January 6th, which was a coup, but it's not a military coup. And in the same way, we don't have a religious figure announcing, I'm now the head of the United States. Instead, what we have is this encroaching theocracy over time.
This is, and I forgot the Muslim elementary schools that would be created. I don't want to forget the Hindu schools that would be created. I think of the Baha'i schools, Zoroastrian schools, the Buddhist schools I could get behind. I think they would be very nice.
Very
no
chill.
ADHD at those Buddhist schools. All those kids are very focused.
Very chill.
This is really important of a case and a space that we should keep looking at. And the other case on the kind of like the same ilk, and you were referencing this with Hobby Lobby, is the Mahmoud v. Taylor, where Maryland parents have the right to opt their elementary school-age children out of instruction that includes LGBTQ plus themes. This was a 6-3 decision brought by Muslim, Catholic, and Ukrainian. Oh, we forgot the Ukrainian Orthodox. That's a whole thing. I mean, how many religious schools are we going to have in this country? I can't keep track. I want to read a little something from Alito, or from via SCOTUS blog, about Alito's majority opinion here. SCOTUS blog, great site, by the way. Writing for the majority, Justice Samuel Alito acknowledged that, quote, courts are not school boards or legislatures and are ill-equipped to determine the necessity of discrete aspects of a state's program of compulsory education. But he emphasized that what the parents seek here is not the right to micromanage the public school curriculum, but rather to have their children opt out of a particular educational requirement that burdens their well-established right to direct the religious upbringing of their children under the Free Exercise Clause of the First Amendment. Direct the religious upbringing of their students by erasing the identities of the classmates that their children go to school with.
That's a great way to put it. I did want to make a quick point about the last clause, and then I'll transition to talking about this one. We were talking about the Establishment Clause and the question of whether or not it bars the creation of these charter schools for Catholic charter schools. One piece of evidence that this is creeping theocracy rather than somehow some inclusionary way of thinking about religion is the obsession of Republicans with Sharia law. that.
Yeah.
So there isn't a parity here aside from the Muslim case. Now, the Establishment Clause limits, supposedly, the role of religion in public life. It's an anti-theocracy principle. And the other principle in the Constitution written into the text is the Free Exercise Clause, and that's what we're talking about now. And there was no idea of exemptions at the founding for religious people, but it's an idea that's been created, actually, interestingly, by liberal justices like Justice Brennan. But it's been weaponized, I think, by the right. And so what you're seeing increasingly, I mentioned the Hobby Lobby case, is the use of the free exercise ideas to try to go after ideas of equality. And in this case, the idea is they're not trying to, end the school curriculum, which teaches tolerance. And let me just say what we're talking about, too, because for listeners, when you break down the actual stories, this is elementary school kids that we're talking about, you really see it. I mean, there's one book in particular that's at issue, which is the teacher reads a book about how this kid's uncle is getting married, and it's a gay wedding, and the kid loves the uncle, and the kid is torn about losing the uncle to this new partner. Now, it's sort of a lovely story about a kid grappling with losing this uncle who she's close to, but the conservatives read into it that she's got a moral objection, which is not true of the story, a moral objection to the gay wedding, and she's being shut down unjustly. So, they're not good at reading the book, but they
Did the book show the wedding? Did the book show how fabulous and well produced the wedding was?
I haven't read it. The book I've read about it, so I can't tell you the details. But I think that's certainly how it ends. The girl realizes she's not going to lose her uncle; that she's going to be included in this new wonderful.
She was at an amazing wedding. That's why she was at an incredible wedding.
So they're saying, I want to opt out my kid from. They have a right under the Constitution, the free exercise clause. So. What's happening too, I was at a conference actually about religious freedom, and somebody described it so well. It's like obviously the two clauses are written into the document. You've got to read them together. And yet they're reading the free exercise clause to essentially abolish the establishment clause. They're growing it, and they're growing this theocratic idea of it, which is that really you have the right to influence policy, you have the right to, they might say eventually a free exercise right to these religious charter schools, so much so that it just gets rid of the anti-theocracy principle. And the more the free exercise winners are evangelical Christians and conservative Catholics, it's that religion that gets embedded into our, becomes theocracy. That's what I think we're seeing.
But what about the idea, kind of like the Hobby Lobby argument, that these things that they're promoting or that they're exposing my children to are so antithetical to the beliefs that I have in my religion that it is impacting the way my child is growing up? Isn't that an infringement on the rights of a parent to raise their kids within a religion?
That's what they're saying, and that is their best argument. I mean, I think, look, we've got to bear down on some hard questions. The way that I see it is the government has to not only protect people's rights, but it has not just an entitlement, but an obligation. And I actually defend this view at length in a book that I did for Princeton Press called When the State Speaks, What Should It Say? And my argument is that people have all sorts of rights to free speech. You have the right in this country to defend Nazism. You don't have the right to act on it or to threaten people, but you certainly could even deny the Holocaust. It's very different than the rest of the world, which has an approach called militant democracy, where they ban, for instance, Holocaust denial or membership in the Nazi Party, go to prison in France or Germany for saying those things as a matter of pure speech. And I rightly think that we don't have that. We don't criminalize speech. But there's a set of obligations that comes with all of these protections, and that's to send messages of equality and not just tolerance, but that we all have an equal place with equal rights in this society. And that's what lessons like this do in school. It's the school teaching the value and dignity of your classmates. I like that way of putting it. And if that conflicts with your parents' religious beliefs, we don't have mandatory public schooling. You can pull them out and send them to a different school, but they certainly have an entitlement to try to send those messages, including to children. And if you have a view of religion that conflicts with basic human rights for gay people, I mean, you don't have a right to keep your child from hearing those messages.
This feels like a fundamental idea of what freedom actually means in America. Does freedom mean that we tolerate others? Because this case kind of presents an argument that freedom actually means I can be on my own and no one gets to bother me or tell me what to do, and the existence of other peoples or cultures and other parts of the society have nothing to do with me, and the Constitution, in fact, allows me to opt out of interacting with them in any way. That's freedom as they define it.
Right. I mean, it even goes beyond that, because really what they're saying is they do have a right to homeschool their kids, for instance, or to opt out of the public school system. But they're trying to commandeer the way the public school system teaches. And they're providing an exemption in each instance in which some religious parent doesn't like, math lessons, for instance, because now that might sound like an exaggeration, but there is actually a famous case called Yoder about the Amish wanting to opt out of the Wisconsin school curriculum that included things like, higher math and interpretation of text in a way that wasn't literal, the non-literal interpretation of text. And they said, well, that is going to infringe on our rights. Now, the Supreme Court, a liberal court actually at that time said, okay, you have the right to opt out. It didn't say you have the right to, within the public school,
make the public school
change
do
the curriculum or have so that was one way of sort of trying. I actually disagree with that case. I think it was a mistake. I think that kids, regardless of what their parents' beliefs are, there's an obligation to educate them, and that means educate them on non-literal ways of reading text, higher math, and hearing that your fellow citizens have rights.
I can't wait till some of these kids grow up and they enter the workforce and they like meet a gay person. Like, what is a gay? I'm sorry. Is that a what is? I don't know. Yeah, I went to a religious school.
It is really crippling kids, I think, to deny these basic.
Of course, this is disgusting.
Yeah.
Listen, I'm so happy we got to do this.
Usually, I got to say, on the Oath in the Office, we're always trying to bring the hope. And I will say...
Oh, no, fuck that. This is a show about foreign policy and geopolitics. Are you kidding me?
We didn't do the
last 2 months? Zero hope, buddy. There is just survival.
All right, well, if you want the hope, you can listen to my podcast.
Go for it.
The Oath in the Office.
Well, I did. I mean, you mentioned free speech, but you also said earlier that the house is on fire. So this does make me think in the context of another big civil rights Supreme Court case that I learned of historically. Can I still run around the theater and yell fire if it's not literally on fire, but figuratively on fire?
Yeah, well, you're referring to Justice Holmes, who was, it's a very famous quote now, almost a cliche, but he was using it in a pretty precise way. He was saying you can't yell fire in a crowded theater if you're going to incite violence, that's not something that's protected. And, that
But you
idea,
can't invite thousands of people to Washington, D.C. to storm the Capitol, and that is not inciting violence.
It is what, we could do a whole
act.
Yes.
We could do a whole episode about that. But interestingly, I thought that Trump should have been charged with incitement to riot.
Of course.
But Jack Smith didn't do it for the First Amendment concern, that he was worried that he couldn't get around that rule in Brandenburg that shows you have a right to free speech unless your speech is directed at the incitement of immediate violence. And, that helped. Trump, uses that First Amendment in all sorts of ways, including in January 6th.
Wow. And even the finish, think we're finished.
Yeah, that line. I believe in repetitive humor, which is that if the joke gets funnier the more times
Feel free to use that. If that
finish and I'm telling you, maybe my Finnish listeners will gravitate over here. So
absolutely,
thank you for that.
Let me know if it works in Helsinki.
Corey Brettschneider, professor of law at Brown, co-host of The Oath in the Office with John Fugelsang, and he's the author of The Presidents and the People, 5 Leaders Who Threatened Democracy and the Citizens Who Fought to Defend It. And, of course, Travis Irvine, Columbia Journalism School grad, our wonderful guest host for today. I'm currently eating ramen somewhere in Japan, so send us an email when this episode drops. Hopefully more wars don't break out between now, today, July 1st, and when this episode drops, I think middle of July. Well, who knows?
And thanks so much, Seena. Thanks so much, Travis. What a pleasure. This was really a fun conversation, despite the fact that, yes, our house is on fire.